Hi, everyone. Harry here to talk about the remarkable and deeply offensive insubordination of the Republicans in the Alabama legislature. It's reminiscent of the worst conduct by recalcitrant Southerners in Reconstruction and then again in the Civil Rights era. All right, here the context is gerrymandering, and the Supreme Court of the U.S. has given very little judicial relief for blatantly lopsided, terrible gerrymandering, but they've got a little sliver left, and that has to do with racially discriminatory, essentially, gerrymandering under the Section 2 of the Voting Rights Act, not Section 5, which was the most vigorous and a Roberts opinion did away with, but Section 2 still exists. And in the flurry of final opinions of the term, the Roberts Court affirmed a lower court opinion that struck down Alabama and its Republican legislature's rank and racially, completely unfair gerrymander. I'll put it that way. So there are about 28% or so African Americans are the percentage in Alabama. They have 7 congressional districts. If you do the math and it worked out naturally, right, you would think 2 anyway of the districts ought to, that the overall numbers should produce at least a couple districts where African American voters get the voter of their choice, not necessarily an African American, of course, but it's so designed so that they actually have the ability to express their preference in their fair numbers. They didn't have that because Alabama had drawn a map that basically put all African Americans in one of the 7 districts, leaving 6 others for white voters, largely Republican voters. And that's what the courts struck down, including the Supreme Court, and it goes back down to Alabama. Here's a mandate, just like, integrate with all deliberate speed in the wake of Brown versus Board. The mandate is draw 2, not 1, 2 majority minority districts. And the sons of bitches in Alabama, I think that's the legal term, got together and said, we are not going to do that. It's breathtaking, really. Although maybe it kind of bespeaks the where we are in the courts and the confidence of some Republican folks that maybe the Supreme Court would give them extra rope and running room. What they went and the 2 houses in Alabama both created a second district that one was like 44% African American, one is 38, but neither is majority. So, and they actually talked about, well, we've done a compromise. Let that settle in for just a minute. A compromise between their rank racist, and by racist here I mean that their absolute design is to dilute the votes of African Americans and, not coincidentally, Democrats. So I give no opinion about the private views of Alabama Republicans, but they just can't draw a map like this after the Supreme Court is done. They did it anyway and said they're offering a compromise between the dictates of the law, the Constitution, and the Supremacy Clause, and their own kinds of views. So it's significant, and of course it's all played out against the context in which every seat counts. So if, as would be expected, Alabama becomes a 5-2 state rather than a 6-1, that eats into the very, very, very narrow majority in the House for the Republicans and Kevin McCarthy. But of course, that would be now the law of the land. And it's just, I think, breathtaking that the legislature gets together after the very conservative court says, no, you cannot do this, and basically does it anyway. Now, there's maybe some hope that when it goes back, in the actual opinion of the Supreme Court, Justice Kavanaugh made some noise suggesting that, you know, they might have some leeway rather than there might be an equal protection clause problem withdrawing a frankly race sensitive map. But of course, that's what it has to be, and that's what the court has ordered, and that's what the Voting Rights Act Section 2 says. So to me, this cannot stand. And if it does, if the Supreme Court and the federal court system accepts this kind of insubordination by Southern Republicans simply thumbing their nose or pretending that a Supreme Court ruling is, you know, just a starting point, man, we are in a world of trouble. So either the system in short order makes them back down, or if it gives them running room, then man, the concept of the rule of law in this country is much eroded. All right, so we can expect no marshal's going to knock on their door and arrest the legislature. What's going to happen is the good old-fashioned American way. There'll be a lawsuit this week, almost certainly, by the people who brought the original lawsuit, and they'll say, "What the hell?" And presumably and hopefully the district court will say, "What the hell?" And it'll go all the way up. The Supreme Court won't even hear it. Everyone will say, "What the hell? You get this in order quickly." Now, there's a terrifying prospect here that happened in this very case where the court, using its so-called shadow docket, actually permitted the election of 2022 to go forward with what we learned shortly thereafter was an unconstitutional map, but they didn't enter a stay, and therefore it stayed that way until they made the decision. There's a somewhat, nightmare scenario where something like that happens, and they give some rope to the Alabama legislature, but A, it's such a flagrant act of disobedience, and B, we've got a while to go until the next election, too long to try to stall out. So I certainly expect that in short order, the Alabama legislature, as it deserves, will, basically have its pants taken down and get a spanking of the sort that legislatures deserve when they utterly ignore the supremacy clause in the Constitution. So it should come, and it should come soon. And if it doesn't, I'll be back really inveighing against the heavens, if not the courts. But you just can't do this in a rule of law. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.